Hey everyone, Josh with the Turner Law Firm here. I wanted to spend a few minutes today talking about estate planning and what are some of the common objections that we as attorneys hear to estate planning. Obviously, the most common one is, well, I'm too young, I don't need an estate plan. So what is an estate plan? An estate plan can be your living trust, your appointment of guardianship if you have minor children, power of attorney for legal matters, or even for healthcare matters. And that is why, especially as a young person, you may want a estate plan. If you have young children, who are they going to go to if you and your partner were to both pass simultaneously? What is going to be the plan for making sure that they're taken care of? If you have medical conditions, what is your wishes in terms of end of life care? So those are the types of things that we discuss in estate planning. If you were to have a terminal condition, what kind of treatment would you want? If you were to be in a coma, what kind of treatment would you want? When we talk about kids, we look at who is going to be the guardian. If you are prepared and have the assets to continue to support your kids that are minor, what does that look like? Another big thing that we hear in estate planning is, well, I don't have any assets, I don't need to have an estate plan. Well, the reality is everybody has something, even if it's a retirement account or your first home, a fixer-upper, or a bank account, whatever it might be. In Arizona, if you have zero estate planning documents, no will, no trust, then you go through some form of probate through Superior Court. That could be a simple process, but it could also, in many cases, be a very long and drawn out process that requires someone after you've passed to apply to be the executor, publish that you've passed in the newspaper, wait a certain amount of time until anybody that may believe they have a debt that is owed to them from you contacts the executor and that debt is resolved. And finally, after all that is done, your estate can be divided up. In the meantime, especially if you have a house and a mortgage, the mortgage is still due, and stuff that needs to be handled every day may not be able to get done while you're sitting in probate. And then if you have no will, the court has to figure out who is going to get whatever assets you might have. A common misconception is, well, a will suffice. I just need a quick, easy will. Not necessarily true. A will is great as a baseline, but it still goes through probate court, and it still has to be published in the newspaper in most cases and wait that period of time. The best option that I typically recommend to clients of the Turner Law Firm is a living trust. A living trust puts all of your assets in one place in the name of the trust, and it avoids going through probate. This allows whoever your executor or successor trustee to streamline the process of dividing up all of your assets. Again, if you have minor children, it lets you make sure they're prepared for while they're minors, that they're cared for, that there's a plan in place, and then whatever may be left over once they turn 18, maybe you want them to get it all when they're 18. Maybe you want them to get some of it for college and wait until they're older and more mature to get the rest of it. The living trust allows you to have that flexibility in how you prepare your estate plan. Another common thing that we do is a special needs trust. If you have a child that has certain special needs and receives any sort of government benefit, oftentimes if you leave them money and it's not placed in a special needs trust, that can affect their ability to receive government benefits. So those are the types of estate planning tools that we utilize here at the Turner Law Firm. We've talked about two of the biggest objections. I don't have any assets and I'm young. The third biggest objection that I hear is, well, I can just go onto LegalZoom or use a legal document preparer. Absolutely you can. There are significant risks involved with that. A document preparer or LegalZoom cannot give you any legal advice. They simply fill out a form based on what you tell them. So if you're not aware of specifics that you might need, such as a special needs trust or a tax deferred trust, they can't give you those options. Hiring an attorney for your estate plan is pivotal because it helps you to choose what is best for you. If you'd like to know more about estate planning or schedule a free consult to discuss your estate plan, contact us online at our website, www.turnerlawaz.com, or at 480-340-2184. Follow us on social media on Facebook or Twitter and subscribe to our YouTube channel. Thank you.